Hello, Legal Eagles. Welcome to Legal Vlogs with ZP. And today we're going to talk about AI and copyright. We're going to continue with the last discussion of AI as a co-creator. Can machine own copyright? This is a revolution, a legal revolution that we're not really ready for at 2025. Traditional copyright, as we had talked about earlier, is based on as human author as the owner of a copyrighted protected material, any. And we have seen through case laws in the last video. We have seen through legal laws that have been protected in the US, in the EU law. We have seen through the Tennessee's Elvis Act, where the AI was not allowed to clone voices. We have seen through a lot of things that we had talked about earlier. But today's video, we're going to focus on whether this revolution is something that will probably come in future or not. And of course, as at now, we have seen that it is not accepted from the cases of Zaira, the comic book Zaira the Dawn, from Tyler versus US, from even the traditional view of the monkey that took a selfie. This is something that shows that we as humans have not been really ready to give something else or something else, because we can say it's someone else, the right to creativity. We know the basis of traditional copyright is on creativity, and that creation is based on human, like there has to be really a substantial human input in it. And that's why we've seen some traditional cases like Festa publication. It ensures that any work has to have the modicum of creativity in it, and that modicum has to be a human effort in it. And that's something that AI is still struggling with, and our legal systems also. We have This is why we have seen the cases like I just had said, the monkey selfie, the Naruto versus Slaughter case. We as humans, I wouldn't say we are selfish, but we're not ready to put out that, because there will be floodgates of whether who's going to be benefiting behind that in terms of ownership. But when it comes to international wide, we have seen internationally, we've talked about US already. As at my knowledge, as at now, and as the knowledge I have as at now, EU has not handled any case in terms of AI co-creator, co-ownership issues. So, but I think the earliest was handled, I think, in 2019 with China. There was a Shanghai case versus Shanzai, something. There were two states where the Chinese courts recognized AI generated financial reports as protected works, and the ownership was not given, of course, to an AI, but to the developer, like the developing organization was given the ownership rights. So I don't know if we are in a science fiction, or it's something that is going to be developed in future, where AI will have legal personality. I don't know. But is it something that we're ready as now? No. We have seen almost most countries are not ready for it. But there was something surprising last year I saw in some of the media, where Saudi Arabia was able to give citizenship to a robot. So if that is going to process, it's going to be another science fiction probably, or something. I don't know. We're just waiting for it. But for now, we are still on basis of substantial human input. These issues of AI ownership, co-creator has really been so fast, and we have emerging issues like I talked about fair use coming in. We have issues of text and data mining, especially in the EU. We have most issues coming in and emerging trends. I think the earliest, not last year, 2023, there was a case on New York versus OpenAI that stretched GPT. We had issues of the comedian. I don't know, she's called Sarah something. So this shows that really we have issues of output. Who is the owner of this output that is being generated? And if there's really limited human output or no human output, to what extent are we going to protect this? And of course, it conflicts with the issues of data. I think I saw in the news yesterday or the other day on the appeal, because I think the OpenAI was trying to appeal because the New York Times decided to keep or reserve the output of Chat GPT, and the OpenAI was arguing that this is something of data protection. We have an obligation towards our users, and of course, in most countries, there's an obligation for a certain period of time. Our data is supposed to be the data of a user is supposed to be deleted if it's not used, or if that person has not logged into an account. Probably 7 to 9 months it has to be deleted. So they felt like New York Times were abusing the fact that they have now the output, and now they still want to retain it for an extended time, which is not clear. Yeah, I'm waiting for that appeal on how far it goes, and in my opinion, which might not be the opinion of most people, this is somehow an abuse of the data of the people, which basically may conflict with privacy commitments of laws, which are very different data in US. And of course, these things that are used in training, they use data almost everywhere. So this is a case that has been there since 2023. This is 2 years down the line. I hope it is not going to set a bad precedent towards the copyright. And this creates a lot of future implications and debates on terms of ownership. Who's going to be the real owner? Is it the developer, the Chinese way, the Shanghai versus Shanghai? Um, is it now the user ownership, or we can go the US way on public domain, no ownership at all? And this raises some ethical concerns and invention. Some people will argue that trying to restrict their ownership just to humans will probably backlash in terms of inventions and AI. And I think this is still a wild card gray area that more discussion has to be put onto it, but at least we have some basics of there has to be just human input in it. Some practical ways to handle this as of now, if you're a creator, if you're a writer, if you're a musician, or any way, the best way to really handle this as at now is try and in every step you're using an AI, try and collaborate human input. And please, if you're writing a poem, you said this and this and this was my own input. This is what an open AI helped me to do. If you're writing a book or a play, this and this, like document your human input in it, so that everything is not grabbed up and say, ah no, this is AI, we cannot protect it. And developers try and implement the licensing agreement to ensure that there is ownership in it, to ensure that there is direct, like, written in it. And we can decide to go the hybrid way, such as, I think there's Japan is using the hybrid models, which is something that we can decide to go. But as at now, this is still a gray area and something that we are not ready for. And they were still playing with the wild cards on on how to handle this. And the best way as a person is just make sure you have human input, because the laws, there is no uniform law in it everywhere. There are more struggles to try and reconcile traditional copyright with the current issues of AI. We expect, of course, more cases to be handled, more laws to come up and more changes. But as of now, this is what we are dealing with. Thank you for being there in this short discussion. And the next one will be something different. See you in the next one. Bye.